It's not. Oh, it is. Okay. Who's that driving? What is that? Okay. All right. Good afternoon, everyone. I apologize for the delay. If the attorneys could please place their appearances on the record.
Your Honor, Christina Stifler, Alan Mizrahi, and Steve Siegel for the state.
All right, thank you.
Good afternoon, Judge. My name is Jesse Dreiser, and I'm here with Shannon Day, my client, Mr. Fernandez, and Frank Tassoni.
All right, thank you.
Good morning, Your Honor. Patrick Carodi and Rosemary Peoples from the Baez Law Firm on behalf of Ms. Shanna Gardner.
All right, thank you. Good afternoon to everyone. And again, I apologize for the delay. We're here for a case management hearing. And I appreciate, did all sides get at least on Mr. Fernandez's case, the discovery issue memo? Okay. Is there anything similar for Ms. Gardner?
Judge, that was done with input from our side as well.
Oh, it was, okay.
Yes, Judge.
All right, thank you for that. So where I was left, I need to, or I want to gauge where the parties are in the discovery process. And my understanding, there's only been the deposition of those two witnesses that were related to the disqualification motion. Is that right?
Yes, Your Honor.
Yes?
Yes.
Okay. How many total witnesses does the state have?
Ooh. I don't have my I know we're numbering close to 100. Obviously, we're not intending on calling all of those for trial, but they are listed as Category A because they have some type of information. I did speak with both sides before Your Honor came out. I received the discovery list from Mr. Dreiser with input from Mr. Baez and Mr. Carodi, and we have formulated somewhat of a plan if the court would like to hear what we've come up with.
Sure.
Many of the items on this list, either there were no responses to subpoenas, meaning no records existed. We've provided some of these things, and I think owing to technical difficulties, which has been an ongoing issue with the volume of discovery and the types of files, some of this has been provided, but just did not transfer over. I'm going to re-provide the items on this list that I do have and are available. Next week, I'm going to go to Jacksonville Beach Police Department with my lead detective, lead ATF analyst, and paralegal and make sure that defense gets what they're missing. We've had some discussions about relisting some things to be more clear and re-providing the discovery in its entirety once they've gotten everything so that everybody has a copy of the exact same hard drive so we know what has been provided, what has not, so that there's a record of when and what the state has provided. I think we're going to begin by working on that, and we have discussed looking to set depositions in the next month or so. I'll let Mr. Dreiser speak, clarify anything or correct anything.
I think our records show 86 Category A's, 27
Okay,
Category
thank you.
B's.
There may have been some added since the time of the filing, so we're close to 90 to 95 witnesses.
Are there, from the defense perspective, and that's to Ms. Gardner and Mr. Fernandez, any of these items that are listed, either on the state's exhibit or what you're phrasing as missing, that you believe need a taint review?
We sent another email this morning.
I've been in court all morning.
I don't think we included you on this one.
Okay.
And what we had said in the email was, I don't believe there are any identified privileged documents that we could think of, with two exceptions. One, any text messages that may be on devices that were intercepted, and they would all correspond, with no exception, to the phone numbers that we provided to the state attorney's office. I don't have two phones. Mr. Tassoni doesn't have two phones. Mr. Hill and Ms. Day, it would be those phone numbers, and there could be text messages out there. There are text messages out there, and I assume the state at some point in time, at some level, at some iCloud has them. Maybe I'm wrong. I don't know. Number two, the wire. There may be phone calls that were recorded. I assume they would have been minimized. I assume whoever was running the wire had experience in identifying legal calls and would have immediately minimized them. But so I'm not in any way accusing anybody. I don't even know that they exist. I'm thinking what could exist hypothetically. With those two hypothetical examples, I don't believe that there's anything else besides what we've spent the last 6 months talking about, which is all those emails and the documents and whatnot. So when you ask the initial question, what needs taint review, or what could, we know that all of those things that are a settled issue at this point are out there, right? We know that Ms. Butler had them at one point. We know Detective Johns had them. We know they're on jump. So I don't know how to fix that. I think if I was making a suggestion, the state should collect all hard drives, thumb drives, next point applications alike, and operate solely off of, I guess, Agent Nazario's last provided.
Can I stop you there for just a moment? What was the status of Agent Nazario's taint review? Did he go through all devices, all the emails and those things?
During the course of his work with the state, initially, obviously, he was provided all devices, so the Cellbrite returns we have for the devices went through the taint process. Ms. Gardner's iCloud return, as testified to and is litigating this hearing, went to Agent Nazario after it was determined that it hadn't gone through originally. And
He went through every single file on there, doing what you all had agreed, which is, in my mind, based on the case law and the law that I was reading, a heightened standard of just content blind, and he's provided those reports to you.
Yes, ma'am. We provided him the Google returns for Mr. Fernandez Saldana and Ms. Gardner as well in November October or November when Mr. Dreiser sent the letter about the two documents. We also.
What about Ms. Gardner's information? Because my understanding from reading the deposition of Ms. Butler is that once she came across, I believe it was a text message. When she came across the text message, she stopped. Then everything was taken down from Next Point. Has Next Point been uploaded again?
So that was
Did you all just stop?
Next Point was not up and running at that point where she was looking through the return. The decision by the state and by Ms. Butler and law enforcement was everyone shut down, deleted what they had, and that return from Apple that was provided to Detective Johns was sent to Secret Service, and we received the redacted version back, and that's what we've been working off of. Next Point, when we got this defense motion, was disabled, all access, and it has remained disabled since then.
Is that what you all intend to use to share information between parties?
We are still determining what we want to do. I know Mr. Dreiser does not want us to use Next Point, even if.
Well, let me be clear. The state can use whatever they like to organize their discovery and prepare for trial. The defense has a strong objection that we want nothing to do with Next Point. What we learned through this issue is that Next Point documents what we look at, when we look at it, when we download it, how long we're on there.
Share to everyone?
They absolutely have access to that, and I don't believe that the state should ever be able to know what we're looking at, how long we're looking at it, what we find interesting, what we don't find interesting. So we're going to operate solely off of providing devices like this, a 10 terabyte to the state at any given point. They can put whatever they want on it. There's no reason for us to use that.
And the original idea behind defense access to Next Point was not for them to use it as a viewing platform, just to have almost a Dropbox available to them that they would just download what we gave them access to, much like the CIP, the portal, and then not use Next Point after they've downloaded each application. So they don't have to use it. We are in agreement that we're going to make sure everybody has duplicate exact copies of the same hard drive going forward, and cross-reference that with the list provided by Defense Counsel today and with the state's discovery demand. And I'll file an amended demand now that this proceedings are not stayed and we've reinitiated discovery. There are some obviously supplementals I need to file.
And
Go ahead.
the list that I sent, I just want to be very clear. It wasn't, the only reason I included the court was I wasn't really sure what today was about. I was trying to create a productive sort of roadmap of what I thought today may be your inquiries. But the state and I have talked. It was not accusatory.
I wasn't taking it like that. I appreciated it because I think the state did do a very thorough job in listing out everything. If you all had, number one, my question, it sounds like since we have essentially been stayed in trying to resolve a very important issue, nothing discovery-wise has been going on. And so I needed to know, based on what I didn't learn through those motions, if the defense, if the state, because I think that I would like the state to put the court on notice if there is a need for a taint review, that we get that accomplished. So, and my thought would be, is that it would be an independent agency, not a federal agency. I believe that frustrates this entire process. They are not under the jurisdiction of this court. Their witnesses have lawyers. They don't answer certain questions. This, unlike the federal government, Florida is a open discovery state, and for them not to answer certain questions on advice of counsel, I don't think would be productive in these cases. So I was willing to go through that analysis, enter an order, basically outlining how I see that it should be done. So you're telling me that the Google Drives, the iCloud, those have all been reviewed for taint purposes. So
Yes.
you all have redacted copies of all of that information.
Yes, Judge, the original unredacted copies are still in the property room at Jacksonville Beach Police Department. I know at least Dreiser Hill has gone and gotten the unredacted copies directly from Jack's Beach. I'm in agreement with what Mr. Dreiser is saying. I'm happy to take everyone on the state's team, including law enforcement, whatever we have. I'm fine to be extremely cautious, an abundance of caution. I don't have anything unredacted, but I don't mind sort of replicating that process to ensure that there is no inadvertent possession of anything. Taking all our jump drives we have currently, all our hard drives, wiping them.
I guess, I don't know how
Reloading
much
it.
of that has been sent via email or communication, not any, or
I'm sorry, you mean the evidence or the instructions?
any of the potential information that may cause problems that the law enforcement or the state should not have access to. Has any of that been sent?
Other than what we talked about in the hearing, which is the law enforcement team, not the state, was on the email for the iCloud that Ms. Butler, began analyzing and notified the state, then they all deleted their whatever email or attachments they had. That was sent to Secret Service, and Secret Service has provided reports to Defense Counsel of everything they received from us and everything that they've gone through the filter process to do. But, and obviously the 2 documents which were in the emails that were the subject. But other than that, I don't believe anything else should be in the possession of the state that is not redacted at this point.
Okay.
But I don't, Mr. Carodi can
Judge,
stand in.
with respect to Ms. Gardner, and I think it was just an oversight, the initial list provided to the state did not include Ms. Gardner's family law lawyers or at least one estate plan lawyer. We know that those emails between them and some text messages did get through the taint process. Because of the way the taint process was done, it was not a content review, right? And so the content review probably would have caught those. So I don't know if a remedy to that would that we provide another list to the state, and the state can then, go back and do another review and remove that information.
Okay. That would be a yes on mine. I think that should be done.
Yes, ma'am.
And
through it-
I do not want Agent Nazario doing it. And
I understand that.
And the state can have another agency outside of and truly unconnected to these proceedings, and I can give you time to identify those people. They need to have, what I learned through the deposition, they need to have sufficient computer forensic knowledge. They are merely to identify and redact. The state also needs to provide an unconnected lawyer, not from the federal government. It doesn't matter to me if it's, the person needs to be unconnected to this investigation, that if that taint agent has a question, there will be directed to ask the lawyer, not the state.
For clarification.
I'm going to write it in an order.
Okay, thank you, Your Honor. An attorney not with the state attorney's office, with a different state attorney's office, a private attorney?
I'm going to think it through, but it needs to be someone who has legal knowledge, the ability to research the issue for the taint agent. I don't know how much information is this? Should it be plural agents?
So no. I mean, if you're doing the search the way they did it initially, us personally, we've probably found about 10 to 15 communications. So that's what we have found. I don't think it's a heavy lift. I think if they're going to do the same sort of content blind review that they did initially, and we give them the email addresses, we give them the phone numbers, I think one person could do it in a day.
Okay, so is that the agreement still, is content blind?
That, we're going to defer to the state on that. I mean, if it.
I need to know.
Right, and we would be okay with that. As as the court identified, that's a more stringent standard than reviewing it and determining the content and whether the privilege applies, which is a legal determination. If we are going to go with reviewing the content, it would be our preference that those exchanges be identified, and then there be a judge that's appointed to review those communications and determine whether or not we would object to someone that is employed by the state of Florida determining whether or not privilege applies.
And I don't think any of that's necessary. I'm in agreement with, we have no interest in reviewing the contents of her attorney-client privilege communications.
So,
Whether they're privileged or not, we're not going to look at them. We'll do a content blind removal of anything.
is FDLE
Yeah,
involved in
that's
this?
what Mr. Mizrahi is suggesting. FDLE,
Are they involved in it?
there is an FDLE report. The laboratory is, but not the investigative agency. And they review.
They have a computer forensic department, don't they?
Yes, ma'am.
Would there be an objection to that? And FDLE has a built-in attorney that they could ask, and any question would not be resolved by that lawyer. The lawyer would be able to help identify and then bring to the court's attention through motion.
Yes, Judge, that's fine, as long as we're doing what the state is saying, is we're just identifying email addresses and phone numbers and then striking the data. So,
Well, if there's a question, I'm going to make the agent / lawyer duty bound to identify it for the parties, putting all on notice, so we could have an in-camera review. That would be my thought, not that they resolve it amongst themselves.
yes, Judge, I think we would have no objection to that.
But I'm asking, is there an objection to FDLE?
No, Your Honor, with the agreement that FDLE then is conflicted out from any future participation or testing in this case, that they are.
They are the testing agency for the state. That's why they have a separate computer forensic department.
Well, that their forensics be conflicted out from any future work on the case.
Do y'all want to think that through before I put it in an order?
Like the computer forensics. So we don't run into a situation where down the road, the same people that are identifying these privileged messages are then tasked with additional work related to this case.
That makes sense.
So as long as we're willing to conflict out that section or that group of people that are assigned to provide on this from further participation in this case, then we're okay with it.
That's agreeable to the state.
First, I need you all to ensure that they have not done any work. I don't want you just,
The FDLE laboratory has done some work. I would have to look at the report. I believe it was ballistics on some shell casings. Our DNA work has been done by ATF lab. I know that.
all right. And what I want to know from the state is whether the Florida Department of Law Enforcement would be willing to do something like this before I put it in an order. If they are willing to do it, it makes sense if they don't have investigative involvement in this, because there is no necessary expense. They have a lawyer that person could go to if they did have a question.
Yes, Your Honor.
And then the question wouldn't necessarily have to be resolved. It would just be identified, and that lawyer could file a motion with the court so that everyone is on notice what the issue is.
Yes, Your Honor, we will reach out and contact them.
Were you going to say something, Mr. Crody?
When you say on notice what the issue is, you just mean a bare bones filing that an issue's been identified. I imagine the state would not be told.
Correct.
Okay, yes, Judge.
Just like my thought would be the way that you all identified it for me, file A, file B, not the contents of the file, not anything being revealed, just that, let's say, list of file A through F are questionable, and put you all on notice because it comes from the defense side. The way that I read the Sullivan case, which obviously wasn't reported, it is a federal case. I thought even though the court was critical of the process, the court was involved in the process, and while not perfect, it does provide an extra layer of protection for the defense and the information that law enforcement is not provided. In that, I don't know if we necessarily need it, if the agent or the forensic person is able just to identify by number. My concern, to me, it was enlightening, but Sullivan, it dealt with the iCloud and electronic information. What I was kind of looking for from the defense is if, with the amount of information, was there anything like what happened in Sullivan, where there were pictures of strategy boards, or if there's any thought about any of that. It didn't just come in the form of electronic information. It came in the form of like pictures on phones, and I don't know if y'all have gotten that far into things that you would want that level of review on those devices. The devices is where I would think it might be the Google return it might be a phone number, an email address, that won't give any protection to the defense.
We spent time anticipating that that may be what we thought the court was going to ask, and we can't think of much more than what I identified earlier in the
All right.
hearing. I mean, look, as all the case law has been coming out the last 5 or 6 years from the Supreme Court down, our phones have become such an integral part of our lives. I can't say, and it would be to our own peril that I can't say that Mr. Fernandez and I didn't have a picture of something that I just can't remember or think of. But we have thought about it, and we cannot think of anything more than what we've identified.
Okay, then we'll operate from that. So I'm going to, by the next court date, I need an answer of whether FDLE would be willing to do what I'm proposing. If it's not that agency, then hopefully you'll have some time to think it through. In my mind, it needs to be whatever, to me, it has to be an agency for the integrity of the evidence. It has to be some type of, or a company, I don't know, that can maintain the integrity of the evidence, not manipulate it. And that there will always be a clear version of what this was and then what is redacted and it comes out. That whatever agency, or I keep saying agency, but whatever company or agency that happens, they need to have legal counsel available for questions. That legal counsel's duty is going to be to the court. They report to the court. I will resolve issues if necessary.
Just so I can give them an idea of the scope, we're including all the devices, all the Google returns, and the iCloud return.
And the wire.
I'll let the court and counsel know that I'm happy to send it to them because there won't be anything to redact. We did not record and minimize any conversations on the wire associated with attorney-client phone numbers. They were just not monitored at all, if that makes sense. They weren't pulled up and then minimized. We saw the number coming in and just did not pull it up, listen, or record it. But I'm happy to send the wire. That should be fairly quick.
Did you include numbers from the other attorneys that may not be, that are unrelated to the criminal case?
As her estate lawyer and her family lawyer, I don't think we had those numbers, obviously, at the time of the wire. We had the Bedell firm's phone numbers and Dreiser Hill's phone numbers.
You need to include those, so that might need to go through a review. I know,
I'm happy to do it. I just wanted to, just for information
Okay.
purposes.
what is the plan for the discovery depositions?
We have discussed, while I'm re-providing some of the discovery, I think we're in basic agreement that we can begin depositions, at least relating to the homicide scene itself, because those witnesses likely don't have any information relevant to any of this supplemental investigation and discovery. So I know there's a lot of defense attorneys to coordinate their schedules. They're going to give me some deposition dates to begin scheduling those. And what we've planned on doing is scheduling 2 full days at a time so that we can take a significant number of witnesses, but we are working with so many attorneys with demanding schedules.
Do you have a time frame?
I'm deferring to defense counsel on this.
We want to get moving. I mean, we're not trying to delay. So I'll send an email out this afternoon to all the defense lawyers.
How many attorneys are coordinating?
So I can't speak for the other office. My office is going to divide and conquer to the best of our ability. So it will not be a scenario where, with the exception of a few very important and specific depositions where I have to be available, Shannon has to be available, James has to be available, Frank, I mean, we understand that there'll be times where we all need to make ourselves available to do this. I get the impression from my interactions with the other firm that they'll operate under a similar way of dealing.
Mr. Crody, you're on the hot seat.
Judge, we have the same position as Mr. Dredge. So there are going to be some depots where I think we're going to have,
I know. What about these initial ones?
I think we can schedule those fairly quickly and divide and conquer.
I think we could probably aim for a June deposition date.
At least for a day, sure. I don't know if we'll get two back to back, but yeah.
Okay. When do you think you'll go through the list and update your discovery?
I'm planning to take the hard drive to Jacksonville Beach Police Department next week, so I'm hoping to have an update by end of next week or beginning of the following week. I'm giving an estimate. It really depends on once I get there, how long it takes me to actually wipe and re-download all of these items. And then cross-reference them with the discovery demand and list or correct anything that needs to be corrected.
And you've put Jacksonville Beach Police Department on notice of the suppression of those documents?
Yes, yes, Your Honor.
Okay.
As well as ATF.
Yes, everybody's on notice. They were all here present for Your Honor's ruling, so.
Okay. Is there anything else y'all want to bring to my attention? I plan to check in like this, probably like once every 30 days so that I can get an idea. I know that everyone wants to get moving, and I know that the information may be vast, and so I need to try to keep on top of, how fast y'all are going, how y'all are plowing through the information. Okay?
There's one more discovery-related item from the state side. It doesn't have to do with providing discovery. It has to do with the minor children witnesses depositions. And Mr. Mizrahi will address it once we're ready to move on from this topic.
Okay.
Your Honor, I just wanted to put it on your radar with regard to the two minor children that are living in Washington. The state is going to seek to have an independent guardian ad litem appointed in the case. And I was asked defense counsel about whether they would just stipulate and agree to it, and whether or not we could just agree to a person out there that could represent the children independently of the mother of the defendant in this case. And they said no, they would object to that, so I'm going to go through the process of contacting the authorities in Washington and see what processes we need to accomplish and whether or not we need the court to assist in any way. I'm not sure that we do. At this point, I think that the Washington courts can appoint a guardian based on the status of the children being witnesses in a case and being under supervision of the family of one of the defendants in the case. I think they can appoint someone just to ensure that the children's rights are upheld. And maybe at some point we could agree on a person, but I just want to put that on the court's radar, that would be something we'd like to accomplish before the children's depositions are taken.
The state is going to take depositions of the children or the defense?
The defense.
It's an interesting issue. I want to depose the children sooner rather than later because they're an important part of our defense. So I brought it up when I was saying, these are where I want to start. And then the state brought up the issue that presented to the court a moment ago, and I have to sort of step back out because I don't have a dog in that one. But they have an attorney ad litem, authority ad litem. There's no difference to me. But in fairness to Mr. Crody and his team, they represent the mother of the children. They do have a dog in that fight. So that's why Mr. Crody and I stuck up. It was at my request to take them, and now it's at their defense of how it should be done.
Judge, we are not going to be a roadblock to Mr. Dreiser taking the children's deposition. I don't know what the state is trying to achieve by seeking a guardian ad litem like 2+ years later after the incident and after our client gave the state full access during the CPT interviews, which are recorded and near in time to the incident. So the idea that these children have rights that they need to be protected, I'm not sure what the state is talking about or what they're seeking to achieve. We are, and we'll fight that battle if we have to in the Washington courts, but we have no objection to Mr. Dreiser trying to depose the children. We will facilitate that. We will make them available. We will make sure that they are in a place that complies with Florida's rules regarding depositions for children. And so I don't know, and if the state files a pleading, we'll review it and respond accordingly. That's the best I can tell the state now, or tell you now, Judge.
Well, I think to just start this whole process, schedule it, get it on your books. And if that's Ms. Gardner's position, then it gives everyone goals to get it accomplished. And then you can start working from that date. But just saying I want to do it and then not having a date, let's put it on the books, okay? All right. All right, well, I appreciate y'all's level of preparation, and at the next court date, I'm not going to pass it off far. I want to have an answer on that so that you all we can start moving. I was thinking, how long do you need with FDLE to make that ask?
I'm going to reach out initially this afternoon, Judge. I don't know if I'll get a response, but I end up close of business, but
Well,
That'll be quicker than the discovery issues. We'll be able to accomplish the FDLE thing quickly.
how about next week? So I have time. You tell me.
The 31st?
Say 31st. Friday.
In the morning?
Yes. I have BOPs, but I can do this first and then go do those. Sound good? All right. May 31st, 9 a.m. That'll be in the next court date. That's for pretrial, both cases. It will always be in this courtroom, just so that you all know. This is ultimately where this case will be tried. So it's the thought that we would get used to this forum. Okay. And I have also, on the state's, on the defense motion, that is in Ms. Gardner's case, motion to set bond and the state's motion for pretrial detention, I've ruled on that, and I said I would do it by order, which I have copies for the parties. I've carefully considered the evidence that was presented during the last hearing, and I've granted the state's motion for pretrial detention and denied the defendant's motion to set bond. I'm filing that now. The original is on top, Mr. Hathaway. All right, thank you. Court's in recess. Yes.
Yes, ma'am. Any help? They're good, they can start taking it.